The second announcement is that Trilog classes or instructional sessions or whatever you want to call them will be resuming this summer on or about June 30th, depending on whether we get our location reserved and we have enough sign-up time. My best guess is they'll be pushed off a little bit since it's only 2 weeks from now, but the first class will be coming up soon. It'll be a Linux 101 class, teaching the basics of Linux, and I'll have information on the mailing list and the wiki, so stay tuned for that. Every month we do a have a job, need a job section, so I'd like to invite anyone that's searching for a job to raise your hand, and I'll give you some mic time now. No one's raising their hand, so we'll get this one out of the way. We'll get to pizza in just a second. Is there anyone that is actively seeking candidates that would like to speak for a moment? No? Oh, yes, one.
My name's Ryan. I'm looking for one person right now up at ARI. We're in the Triangle. Well, obviously, we're up in Morrisville. How's that? So, looking for someone who has possibly some experience as a developer or possibly some experience as a system administrator. I really don't care. The criteria really is that you be wicked smart. So, if you like to work long hours for little pay, in an environment that really is 100% open source friendly, come talk to me.
What was the name of the company?
ARI.
Okay, we're going to get some pizza and drinks now. If you are a first-time attendee of a Trilog meeting, please raise your hand.
Wow.
Okay, you have 10 seconds to get your pizza.
We do have some openings right now, and several different needs, you know, Unix, Linux, sysadmins, project managers, business analysts, .NET developers, Java developers. So feel free after the meeting to come and say hello, even if you're not interested, introduce yourself to me. I'd love to meet you guys, and hope you enjoy your pizza and drinks, and we appreciate you letting us be a part of your meeting. Thanks, guys.
Thank you.
Okay, if there are no further announcements, we'll get the meeting started. Our topic, oh, Cristobal, sorry. You have an announcement.
He's got their audio specialist over there.
It will be available through AWS.
Probably both.
Thank you.
Hi, I'm Cristobal Palmer. I am the Trilog Vice Chair. I'm also co-president of the Carolina Open Source Initiative, a student group at UNC. Our other co-president is over there, Doug Whitfield, wave, and you can thank us for the taping that is happening this evening. But the real reason that I'm up here is to issue a call to arms. We are looking for sponsors and collaborators to help us with Software Freedom Day, which is a worldwide thing that is happening September 15th. At Carolina, we are going to be having festivities on the 14th because it's a Friday. And if you want to help out, or if you want your company to be a part of Software Freedom Day, please get in touch with me, Cristobal Palmer, or Doug Whitfield. Corner us after the meeting. Thank you very much. Oh, and I would also like to thank Ron Jaffe for a generous donation to Trilog. He gave me a check before the meeting. Unfortunately, he could not make it to the meeting, but he sold off some stuff on the list and donated it to Trilog. So everybody thank Ron Jaffe.
Thank you, Cristobal. Yes?
I just want to let everybody know, if you want to have a beer after the meeting, we're going to Sammy's around the corner.
Try Chug.
David McDowell will be hosting Dry Chug at Sammy's on Dave and Ferry, just around the corner, right after the meeting. So see you at Sammy's. Again, if there are no other announcements, we'll begin the meeting. Our guest is Sapna Kumar from Duke University Law School, and she's going to speak this evening on GPL version 3. Let's give her a big round of applause.
Kumar. I'm a lecturer at Duke Law School, and I'm really glad to be here. GPL version 3 has been a lot of fun watching it slowly unfold and watching all the cat fights that have gone on during the different versions that have come out and almost at the finish. And what I really want to focus on today is the threat of patents. I had originally planned on talking more generally about the license, and then Microsoft came with their 235 patents and all hell broke loose. And so I kind of feel like that this is the real threat that's going on, and this is where GPL v3 is going to meet its first test. So that's how I chose that. Just to kind of start things out, I didn't mean to make Torvalds look fat there. That was just a bad formatting. V2 versus V3, the ideology divide. Just getting to where we are now with that sort of being in the end stages of the license of V3 coming out. We've seen a huge divide go on, and because this is a Linux users group, I think it's appropriate to kind of give a nod to it or mention it at least. We have on one hand the Torvalds camp, which, and granted this is my own opinion, so feel free to jump in, disagree, or make catcalls, but we see Torvalds taking almost more of a libertarian approach, saying that the point of the license, the point of the GPL isn't about snuffing out proprietary software per se, but rather giving open source a chance to show its superiority and to prevail in the marketplace, basically to create more good software. And then you've got Stallman, who recently we saw go to Cuba. Some will say leans socialist, some will say embraces all the camps, depending on what your perspective is. But basically you have the idea that proprietary software is morally wrong. It's kind of where you get into flame wars between FOSS versus open source, whether you're having a sort of moral imperative with your license or whether you're just looking for a legal document that at the end of the day will help you license your code. GPL3 is a compromise, really, for both of these camps. I mean, there's been a lot of input that's gone on through the whole development of V3. I mean, IBM's had their say, Red Hat's had their say, lots of small users have too. So we at least, we're kind of seeing the two sides come together a bit, but Torvalds is still saying a lot of nasty things on the listserv, so we'll see if the kernel ever makes it over to V3 or not. So what does V3 fix? Before I get into the evil patent stuff, I just want to give a little bit of an overview here. Right now with the patent provision that we have, the part of it that I like the most as a lawyer is that if somebody is licensing you software under the GPL and then they turn around and try to sue you with their patents, you now have protection. And in the US, this actually isn't too big of a deal because courts generally don't let people give away their stuff or purport to give away their stuff that people can use and then turn around and say, oh, by the way, you have to pay me for it. But it's important in that in that the GPL is used internationally, and not every country gives that protection to its citizens. So I think that that's a major breakthrough. Apache compatibility, that's kind of a 11th hour thing that we got that only came out in the last call draft. But the fact that they were able to hammer out their differences, I think, is a big step forward. Clarifying who's entitled to the source code. I apologize to those who are at the CarolinaCon talk because I already mentioned this briefly, but there's sort of a misconception, and V2 doesn't make this clear, that if you don't have you're not in possession of software, you can't just go and knock on the door of an open source developer and say, hey, give me your source. You have to have a copy of the object code first, and then the license gets triggered, and then you can go and request the source code. What can you do? Oh, sorry?
Could you say that again?
Oh, sure. Let me slow down. let's say there's a company that you know is modifying source code that's licensed under the GPL, either V2 or V3, and they're distributing it. Say, there's maybe a small number of people, like, a company is making modifications, distributing the software to 10 people. You really would like to get a hold of that software. But if you don't have a copy of the object code, if you don't have a copy, an executable, you have no right to ask for the source code. They don't have to give it to you. So if they only gave it to their 10 buddies, and their 10 buddies don't want to hand you a copy of it, then you really don't have a recourse. It's a strange feature, and for some reason the FSF is comfortable with this. But you can't just go knocking on someone's door and say, hey, give me the source code. Like, for example, the fact that Red Hat makes their source code available on the website, to anyone who wishes to download it, it's something they choose to do. It's not something that either V2 or V3 requires them to do.
When you say source
Yeah.
code, do you mean the actual code?
Yeah, I mean the actual source.
And the object code, it could be in the form of firmware, or does it have to be actual, a printed out copy of the code?
That's a good question. You have to, I'm not actually sure how clear it makes it. It says to possess the object code. So you're making a good distinction, right? Let's say you have a printed out, printout of the object code as opposed to a machine readable copy. That would be at the interpretation of the license. It could go either way. I mean, I would say you're possessing it, you have a copy of it, right? That would be my opinion, but both V2 and V3 are very ambiguous in a number of respects. So it's a point that I always try to make. Is that what the GPL isn't what Richard Stallman tells you it is. It isn't what even Moglen says it is, or what I say it is. It's really what judges say it is. And in the US, we haven't had any cases that have reached an actual written decision or written opinion from a judge. We only have 3 German cases, which isn't really useful for those of us over here. Yeah, Christian.
I was just going to say, I think in this license, as opposed to V2, object code is defined as anything that isn't source code, pretty much, like any representation of the program that isn't the preferred version for modification is object code. So a printout of the object code for the purposes of the license is probably object code, even though it's a little weird. So.
Yeah, thank you. That's a good clarification. Sorry. Anything that isn't source code, he's saying, is object code. So even a printout, say you had just the, big reams of paper with the object code written out on it, would count as having the object code in terms of being able to then ask the coder for the actual source.
And that's a GPL v3 clarification?
Yeah, that's a GPL v3 clarification. They just spell it out a little bit better. So I think it's, any clarifications on this license is a good thing. I think ultimately version 3 makes things a lot more confusing, just given how much longer the license is, and the fact that I can read it several times and discover new things each time or interpret it different ways, which as a lawyer kind of scares me. But ultimately, again, it's gonna be what a judge decides. Really quickly, when can you license under version 3? And I just want to make this distinction because of the number of flame wars that I've seen on the topic. When you look at stuff, say that Linus Torvald has authored, like the parts of the kernel he wrote, usually you see something along the lines of, this software is licensed under GPL v2. And that's it. It just says GPL v2. If that's the case, you cannot fork it and license it under v3. It has to say something along the lines of v2 or at your option any later version, or v2 and later, or v2 and v3. But if it only says v2, you can't, without getting permission from all the authors, take it and then release it under v3 for your changes. So it's something to keep in mind. the Microsoft threat. Now this is really what I want to focus on. We have 235 software patents, and we don't know which software patents they are because Microsoft cleverly is not going to tell us. Perhaps taking taking something from the playbook of SCO, oh yeah, we have these patents, but we're going to keep it a secret for a while. So we don't know if they're good patents. I mean, it's quite possible that they're all junk. I mean, we have no way of knowing until we get the actual patent numbers. They just have too many patents that they own to be able to figure out what it is that they're trying to sue, that they might sue under. So for now, we're in the dark. I mean, if they're good software, well, I really don't think any software patent is a good one, which I should start with, but yeah, I think that was one of our greater, I think the Copyright Act is screwed up enough without having this whole mess of giving 100 years plus of protection to code. But even whether they're enforceable or not, the Patent and Trademark Office is notorious for letting bad patents through because they're incredibly understaffed and they quite frankly don't have the budget to hire the brightest examiners. I actually met some patent examiners before and they're like, yeah, I saw an ad in a paper. It said, do you have an undergraduate degree in computer science? Come join the PTO. And you wonder what people choose the government route to begin with as well, so it's a self-selected group. So there's a lot of bad software patents out there. It's quite possible that some of these are invalid. So it's something to keep in mind from the beginning. Yeah?
Does it matter if they're invalid? I mean, isn't the whole idea just that you have the threat and sue? I mean, you can still sue somebody for a bad patent and play legal roulette with them. I mean, Microsoft says I violated the patent. They've got 20 of you, and
the microphone.
I've got very few, funds to fund a massive legal case. Does it matter if they're bad?
No, the threat is. Sorry, technical.
Just repeat the question.
If you could just summarize his
I
question.
understand. The question is, isn't the threat of patents enough to put the fear of God into anyone who's using open source software or Linux or anything? I mean, just the fact that Microsoft is waving these patents around, isn't that enough? And I absolutely agree. The fact that they're saying they have these patents is going to be enough to scare people away who would have otherwise gone with a Linux solution or another type of open source project. Instead, they're gonna be scared. They're gonna see this potential threat. But at the same time,
Or potentially scare Linux distributors into licensing agreements with Microsoft, like Linspire today.
Oh God, yeah! Don't even get me started on Linspire and all these Novell. Oh, I will. I mean, it's the number of so-called open source groups that are now working with Microsoft is really quite scary. So yes, it's still a huge threat, but I think the bigger point is if these patents are invalid, or even let's say a fraction of them are invalid, sooner or later they're going to have to disclose what they are. I mean, if Microsoft goes around threatening people and sending letters or saying you're violating our patents, sooner or later they're going to have to disclose what they are. And I mean, I'll talk about this more as we go along, but ultimately, when we figure out what patents they have and figure out what looks valid, I mean, software patents aren't God. You can code around them. I mean, not in a literal sense. It's not that these aren't patents that are covering chunks of code. These are, concepts. But Linux has existed before Microsoft had any of these 235 patents, and it will keep existing as long as people are willing to invest the time to work around the patents.
My question's more, does it even matter though if they're bad patents? Because the threat of being pulled in the court with 10 Microsoft lawyers doesn't, your legal cost is so outrageous that ultimately it doesn't matter whether you win or lose, you're still bankrupt. Yes. So in the end, the threat of being sued with the patent is bigger than whether the patent's valid because you've got to go to court to find out. you know,
Yeah.
do you work pro bono on that? You know? That's
The
problem.
fact that you have to go into court in the first place is an excellent point. It's extremely expensive to defend yourself against a patent suit. However, I would hope in that case that people in the community and that attorneys like myself would be so eager to see a victory for open source in the US that we'd pull together. I mean, I think as it is right now, if you get sued on, you know, when you get sued on a lot of like privacy related issues, First Amendment issues, there are groups who will come in and who will defend you. I think a Linux related lawsuit or an open source related lawsuit would generate that kind of attention and would hopefully bring those of us who can do something, you know, to the courtroom. Yeah, a bunch of hands. Let's start here.
What? I really need a microphone. Okay. Why is BSD not in this at all? I mean, BSD has a travel file and they're not covered.
The BSD license?
Market share.
Well,
Thank you.
Why isn't BSD being targeted?
Oh, BSD isn't being targeted because the terms are so lax, right? Anybody can use BSD as long as you're willing to like give a little bit of credit and a pat on the back. I mean, it's not a very high standard to meet, and so there isn't the financial incentive to really go after the violators of BSD software. I mean, Microsoft, I mean, there was an incident, I think, involving Hotmail, where when Microsoft took over Hotmail, they found that BSD code was being used without, you know, attribution. But I mean, if you go to court and you say, gee, judge, they didn't put our name on it, I mean, there's not a whole lot that you can get. So I think that's why you don't see the attention focused on it, even though it is, you know, it is used enough to where you expect to see something in the news. But I think that's the answer to your question. In the back? Oh, okay, first you, then that gentleman.
Just to make a point, also should be noted that Microsoft Windows uses BSD's network stack code.
No, that's...
They pulled it right from it. So.
Yeah, no, that's a very good point. Microsoft borrows very heavily from BSD.
In 2005, our company switched to open source. Before our management would allow us to do that, they required us to go to a series of patent attorneys for a risk analysis on what that would mean in order to change everything over. The law firm that we went to, they basically outlined what our risks were because our management and the upper management was unwilling to make the commitment unless they knew what they were getting into. Again, they were concerned about a lawsuit and what it would do to the services. Interestingly enough, in 2000, at that time, the attorneys of this firm up in Washington said exactly what you said, that a number of these patents could be actually bad patents, but what they predicted was a cross-licensing effort because cross-licensing bolsters even bad patents, and that he said once you start to see that, you'll see that Microsoft is going to go on the offensive versus just remain neutral.
It's a good point. Once Microsoft actually, you know, starts suing people on these patents, it's going to lead to an arms race. I mean, IBM's going to bring out their patents, Red Hat's going to bring out their patents. Everybody is going to come to the table with patents, and it's going to be one giant free-for-all. Moreover, once they bring out the patents, then it's all over because people can look at them and say, okay, what can we do, you know, how can we change the source code so we're not infringing? I mean, if the patent is infinitely broad, it's not going to be upheld, and if it's sufficiently narrow, then there's going to be a way around it. So, yeah.
I don't see any advantage for Microsoft to rebuild its hand.
Oh, of course.
I think they're just going to bully everybody. And with their deep pockets, in a court of law, it's all about who's got the deepest pockets.
No, I agree. Microsoft is going to bully people as much as they can get away with. sooner or later they're going to have to reveal what those patents are. And it depends on what kind of bullying they can get away with too. I mean, if they start sending letters to people, for example, saying you're infringing our IP, then that's going to force their hand. The courts are going to require them to disclose the patents. But yeah, with these vague threats, like what they're making with press statements and so forth, that is enough to scare people without being able to get them to stop.
Yeah, it's not a matter of right and wrong, it's just hard
But-
money.
A quick question on the vague threats thing. If so there's no recourse for some companies, say for example Red Hat, to say these vague threats are damaging our business and take them to court and force them to disclose. There's no other way into it except for Microsoft to make aggressive statements saying you are infringing. Stop this now.
There are a few things that you can do. First, there's state unfair competition laws, and this varies state by state, so I'm not licensed in North Carolina, I'm licensed in Illinois, so I wouldn't be able to tell you, for example.
Isn't that the same suit that Red Hat has against SCO that's still pending?
That I don't.
Yeah, I believe one of them is one of them.
There are unfair competition issues going on in SCO, but that goes to copyright. That's more of a copyright suit than a patent suit. So there's kind of other issues that go with that. But yeah, so you have state unfair competition law that may work, and I can't tell you specifically because it varies state by state. But usually, it's to the extent that you can't just go around claiming that you have the rights to something without, giving proof of that or without being able to back it up. And I'm forgetting what your second question was. Sorry.
Is there any other route into a show? Yeah. Is there any other route into a showdown?
I just knocked this cord. Sorry. Is there any other route to a showdown? You can also, there is one other route, which is you could sue for a declaratory judgment stating that you do not infringe the patent. This is a really risky strategy, however, because once you go into court and say, am I infringing this patent, then if you are infringing the patent, you just open yourself up to a lot of damages. So that's not a particularly popular one. So yeah, I think that state unfair competition law would be the best bet. Yeah, in the front.
What about the frivolous lawsuit? That they are using the law in a frivolous manner. What about that as an argument to fight them?
It's a really, and the question was regarding what about the fact that they're just bringing a frivolous lawsuit. I guess assuming that this is a frivolous lawsuit, assuming that none of these patents have merit or they've just puffed it up with a lot of patents, either way. Unfortunately, the current state of the Patent Act is so pathetic that it doesn't really give people grounds for, say, getting money back if you get dragged into a suit over some really ridiculous, clearly invalid patents. And a lot of the patent reform movement that's going on right now and that Congress is considering, is looking at these issues, particularly at least getting money back after being in a lawsuit and having to defend yourself against a patent that's just completely ridiculous. So it's not, currently no, hopefully in the future that will change. In the blue?
Seeing some of the news that's been developing over the last couple of days, I was thinking earlier that it's a protection racket.
What do you think of
I'm
that?
not even sure how to respond to that.
Yes.
Yeah. Yes.
In the last couple of years, some of our government customers have been switching to open source. The information today about Linspire signing this cross-licensing agreement, one of our customers called us today and said that in speaking with a Microsoft Fruits of the Poison Tree.
Well, fruits of the poison tree is actually a criminal law type of argument, so I don't think that wouldn't be an issue if you had done work using an infringing operating system, say, or using infringing software. The person and somebody sues you later for using that using the software. They're not going to be able to get at your work product that you did as a result, assuming you're not incorporating code that belongs to them. Just because they, let me back up a bit. if they're actually practicing somebody's patent, let's say Microsoft has a patent and they sue an end user who used ideas that were covered by this patent to create software. The customer would have to change the software so that they're no longer infringing the patent. But I don't think that a judge would be like awarding percentages of royalties necessarily if it wasn't a clear-cut case. Yeah, sorry.
Let me give you, let's say that Microsoft discovers they have a patent on, and somehow it's upheld of device drivers.
Okay.
Since they invented device drivers. Since you're using a laptop right now that has a video device driver, which is a Microsoft invention, you could present this, and presumably you created it on on Linux. Then do they own your? I think what he was.
Do they own my
own
presentation?
Your work product here, the presentation.
No, I mean if it's just a tool that they have the patent on, they don't own your the things that your creativity led to. I mean they don't. It's like saying if somebody had a patent on the typewriter and you typed a book, they wouldn't own that book. They don't. They'd be able to sue you for damages because you used the typewriter. If that makes any amount of sense. Keep them flying. I think there's someone, in the red.
What about abusive process?
Abusive process for filing the suit in the first place or making the claims. That goes back to the earlier question. Currently, the Patent Act is such a poorly written statute that there really isn't much you can do. Even if you get sued by for a frivolous patent and you have to spend hundreds of thousands of dollars defending yourself, you can't even get that money back in most cases. That's in contrast to the way things are in Europe, which is why those GPL lawsuits that I was telling you about have all taken place in Germany. Because in that case, you can get cost shifting, you can get your money back. But that's one of the things that they're moving to change with current patent reform is being able to get money back for frivolous lawsuits. So I'm going to just dive into this here so I can eventually get to the whole Microsoft Novell deal of evil. Just briefly, I mean, I think you all know, I think you all have an idea of what's going on, that Microsoft is giving a whole bunch of money to Novell. Novell's promising future revenue, and most importantly, Microsoft promises Novell's customers not to sue. And there's certain exceptions within that, but I mean, they're not really important. They're just saying that users of SUSE Linux Enterprise Server who are paying customers won't be sued unless you make changes and distribute additional copies, which of course completely shatters the spirit of open source software. So, does version 3 of the GPL stop Novell? And I'm sure most of you have caught this by now. The answer is no. And of course my slide cuts off here. But there's a date embedded into the final version of the GPL that says if you entered into one of these deals prior to, I think it's March 29th of this year or something, you're exempt. So Novell is completely off the hook. Yeah.
What about all the rest of the distributors that have been entering agreements like Linspire today?
Well, see, now that's a good point. If you're a distributor, then it's a different situation, which brings me to my next slide, is V3 stock Microsoft. But the distributor would be an easier case because...
Well, but in this case, the newer agreements, the Linspire and Xandros, that came out completely after March 20 whatever.
No, exactly. They're after the cutoff here. So yes, they're going to be affected. They have no way to wiggle out of this. But the big issue that's going on right now is involving these coupons that Microsoft has. I don't know if any of you have been following it. Basically, Microsoft has something like around the lines of 70,000 coupons that entitle you to 3 years of service. 3 years of priority service for SUSE Enterprise Linux, and they're selling them to people, and there's no expiration date on the coupons. And so there's sort of a creative argument that's going on saying that Microsoft's patent protection that they're currently offering to a small number of people will have to be offered to everybody else. And it's an unusual, it's a really strange argument, so I just wanted to get into it a little bit. The Free Software Foundation, particularly Eben Moglen, have this interesting theory. What they're saying is this: Microsoft is selling coupons for service. They say this is the same thing as conveying GPL code. And then they make the further argument, well, some people who receive these coupons are going to redeem them after GPL v3 actually goes into effect. And the argument then goes, this will somehow trigger, well, this will trigger version 3 and require Microsoft to extend its protection to everybody. Now, I really, really wish this was the case, but it sort of sounds too good to be true, and it really is too good to be true. I love this quote from the Slashshot user wrote, and so I liberally lifted it. What if the GPL were changed requiring any distributor to give $100 billion to the user? Would that bind you? Well, clearly it wouldn't, right? You didn't agree to this license in the first place. You're Microsoft. And you entered into this agreement with Novell prior to version 3 being released. And you weren't a party to this license. You didn't click on anything saying, I agree. So you can't be triggered just because of something a user does after the fact. You weren't in control of what that person was doing. Just because they redeemed their coupon 2 months after version 3 doesn't mean that they have to follow these terms of this license. Like I said, version 3 wasn't in effect when this deal happened, which is part of the issue. So let's change it around a little bit. What if Microsoft distributes these coupons after version 3 goes into effect? Because then they've seen the terms of the license. If they redeem these coupons, if they sell these coupons, will they have to extend their patent protection out to everybody else? And this is where we get into what would a court do. And given the way our patent system is, it's very, very unlikely that a court is going to say, well, there's this license or contract, or depending on which side of the political spectrum you are, that Microsoft never agreed to, but somehow they're going to be bound to the terms just because they're giving out these coupons. It's a difficult argument to make that Microsoft is willingly, that Microsoft is somehow a party to this and agreed to these terms. The other potential issue is Microsoft could just change the terms of the coupon. I mean, what's in this coupon is under basic contract terms. So they could just say, okay, well, we won't accept the coupon, we'll give you something equivalent to it. It depends on what's written on the coupon. No one who's given a theory for this has actually produced a copy of what the coupon says. So we're kind of all guessing here. Even if the FSF is right, even if this coupon theory is somehow going to cause Microsoft to license or to give their patent protection to everybody, it's not going to help the chunks of kernel that are covered by V2, but which is anything that Linus Torvalds wrote plus a lot of other parts of the kernel. I don't know what percentage, but anything that's under V2 isn't affected by patent licensing under V3. So that's not going to help either. Microsoft can sue away for any kernel violations that may or may not exist. So what's the bright side of this? This is all really depressing. First of all, the software patents can be defeated. Usually, like I said, the PTO has a habit of letting through some really bad patents, even bad by their standards, not just bad by our standards, which is all of them. Once that lawsuit happens, now I agree, a lot of damage can be done in the meantime, so it's not a good thing whenever Microsoft gets up and starts threatening people. But once those patents, once we know what they are, the lawyers can step in and start invalidating them, at least some of them. And for whatever is left afterwards, say half of the patents are still standing, that's where you guys come in. This is where the community can show what it can do. This is where the Torvald side that's yelling at the Stallman side look at each other, shake hands, and say, all right, we've got a common enemy here, and we need to start doing some recoding. I mean, that's ultimately the reason why that Microsoft isn't telling us what those patents are, because they know the power of the open source community. They know that if you get enough people together looking at this patent, you're going to be able to figure out some way around it. So what else can you do? I want to bring this up because I'm not sure a lot of people besides lawyers know about it. There's something new going on in the patent office called peer-to-patent. And oddly enough, Microsoft is one of the companies that's agreed voluntarily to take part in this. And what happens with peer-to-patent is any of you who want can go to that website. There's a link to the USPTO, like to a form that you fill out. And once you sign on, you get to look at patents that people are filing, that people who voluntarily participate, including Microsoft, are trying to get a patent on. And then you get to start looking for things, you get to start looking for prior art and saying, no, this patent is bogus, and this has already been done 10 years ago, and here's the proof. And if enough people, I'll get to you in 1 minute, if enough people get involved with this, it's possible that some bad patents won't be issued in the first place. Yeah?
On the peer-to-patent thing, would somebody be able to contest a patent on grounds of obviousness as well as prior art, or only prior art?
Right now, it's only prior art. Basically, what it allows you to do is you get to flag prior art that you think is important, and then it goes to basically a top 20 list gets compiled, plus everything else that people have suggested, and that goes directly to the patent examiner's attention. Now, the downside is the patent examiner still ultimately makes a call, but these aren't people who are incompetent as much as these are people who are pressed for time. I mean, I think the main reason we get really cruddy patents through is because the average patent only has 18 hours of examiner time spent on it. So, I mean, you can imagine the most complicated looking patent you've ever seen, and maybe you've never seen one before, but these things can be like, 80, 100 claims that are in something that looks like it was translated out of Japanese by a piece of software, and it's not really comprehensible to humans. So you take that, and you have an examiner who has 18 hours spread out over 4 years, and you get some really bad stuff through. So being able to just bring prior art to the examiner's attention will go a long way, or will at least make a difference. And as I said, it's still voluntary, but Microsoft has agreed to it, along with a bunch of other companies, Red Hat, GE, IBM, I think Computer Associates has signed on as well. So there's a lot that can be done in terms of preventing future, decreasing the future number of bad patents that Microsoft can sue on. So I'll now just turn it over to any random V3 or the like questions that people have. If anyone, yeah, in the red.
Is there any chance that when it gets around to the recoding option, that Microsoft will just say, no, that's still covered, and tie you up in court again?
That's a good question. After you do the recoding, can Microsoft say you're still violating the patent? Yes, they certainly could. They could certainly keep trying over and over. They do have to contend with how much they're going to ruin their reputation in the process. And I'll point to SCO as a shining example of this. I mean, not that they have a great reputation to begin with. I mean, I think for most of us here, if not all, they're already as low as they can get. But for SCO, they've watched their reputation just get dragged through the dirt the longer the lawsuit stretched out, and as soon as it became clear to people that they really didn't have anything to stand on. So I think that'll help to some degree with regard to Microsoft just coming back again and again, because people are going to be enough already. And moreover, judges won't like it either. I mean, they don't want to see cases dragging out for 5 or 10 years. It's a good question. Yeah, in the black.
So, I know that the SCO case is about copyright, but one of the things that SCO has done to prolong this is to basically say, here are the violations, but we won't tell anyone the violations unless you sign a non-disclosure agreement. So basically none of the kernel hackers were willing to sign the agreement. Is it possible that Microsoft could engineer some sort of similar deal with their patents so that they could actually sue on the patents but not have to disclose them to the public at large?
First of all, patent litigation and copyright litigation do tend to be handled a little bit differently. But in either case, you're going to have a district court to begin with, and the judge might not be experienced about patent law, may not keep good control over his or her courtroom. So I think part of the problem with SCO is the judges, right? The judges haven't insisted on SCO coughing up their lines of code and SCO, showing what exactly the basis of their suit is. A lot of that would depend on the luck of the draw then, and in that sense, Microsoft would have the upper hand. They'd get to choose where they sue, depending on where the other company is located or the user. So yeah, it's possible. Anything that happened in SCO could possibly happen here. I don't want to try to glamorize patent litigation. It's the nastiest.
See, Microsoft could become a penny stock.
We can hope. SCO is such a funny case because they didn't have any software they didn't have any product to begin with, and they just told their shareholders over and over again, we're going to make a whole lot of money by having these lawsuits which drag on for years, which is, when you're spending money to keep suing, it's not really a winning situation. Yeah?
So, related to SCO not having software, as far as I can see, the V3 doesn't protect us against patent trolls who don't produce software. Is that in your mind a correct reading?
True. At present, nothing protects us against patent trolls, not in, or against any, in any industry, not just software. I mean, I know telco companies that have been affected by telecom patents. That hopefully is changing though, because right now, as part of patent reform, one of the widely supported measures is to put limits on companies that only hold patents but don't actually practice any of the patents. But we don't know what's going to come out in the end. It's such a big free-for-all going on. The hope is that by the time the legislation is done, there'll be something that will limit either when patent trolls can sue or how much they can sue for. But that threat, I mean, no amount of extra verbiage that you stuff into this already bloated license is going to prevent, it's going to keep us safe against patent trolls, unfortunately. They're just the bottom of the food chain as far as patent owners. Yeah, in the front.
Could you define patent troll?
Oh, I apologize. There are companies out there, and these companies don't do anything except buy up patents to sue on them. So they'll go to companies that have a patent, offer them a price, and then once they have the patent, they get the right to sue for past infringement. They'll get that as part of the deal. And then they'll go around and they'll find anyone they think might have been violating that patent for the last, however long it's been around, and just start suing left and right. And having worked in patent litigation, we just absolutely abhorred these companies because you could not make them go away unless you paid them money. It's actually part of the reason why GPL v3 has an exception in the license saying if you have to pay money to a patent troll to make them go away for something open source, something GPL related, we're not going to penalize you for that. We know how bad they are, and sometimes you just have to throw money at them. That's a good question. Anyone else? Yeah, in the back.
Under U.S. patent law, if you're found to violate the patent, making show that you had prior knowledge before it's released, it's triple damages, right?
Yes, if you are knowing, or it's called willful infringement, if you know about a patent and you continue to violate that patent, then yes, you can when the patent owner wins, or if the patent owner wins, they can get treble damages, which is 3 times the amount awarded to them. So it becomes important if once Microsoft discloses what those patents are, that quickly people mobilize and try to inoculate the code against it.
What do you think is going to cause Microsoft to show their hand?
Yeah.
That's probably the $1 million question, or the $240 million question, I should say, given the amount at stake in Novell. What will force Microsoft to force their hand? I don't honestly know. I wish I could tell you. It may be that a state attorney general tries to take action under their unfair competition laws. It may be that Microsoft finally gets greedy enough and wants to go after somebody for money. But I don't know what it is that's ultimately going to trigger it. In the red?
The chip designer I know tells me that the state of the art in chips now is such that you can make chips that are essentially impossible to reverse engineer. So what happens if the equivalent of some code is embodied in a chip, and somebody says, well, what it's doing is actually equivalent to our copyrighted or patented code, but they can't prove it.
So if the patent holder, what you're asking is what happens if you have, say, a chip that can't be easily reverse engineered, but its function is similar to that covered by a patent. There's still possibility that the person could sue you as a sort of a fishing expedition. They really have no way of knowing for certain whether or not your chip is using the same process as their patent, but the outcome looks similar enough. Those suits tend to get thrown out pretty quickly if you can, if you have the documents to say, no, we're actually doing something completely different. But yeah, I mean, it's always possible, and I hope, again, that's one of the things that patent reform will make a difference with. Let's see, there's someone in the back? Yeah, in the blue.
Yeah, but is it just completely intractable to sort of rank the Microsoft patents? You said earlier there's so many that 35 is, I guess, a vanishingly small amount, but do you have a feel for how many overall patents they have?
Oh, goodness. I don't know. If someone has internet access, you could just go to the USPTO website, go to the patent searching, and just search assignee Microsoft, and you'd get a number for it.
Like orders of magnitude more than
1,000s.
I mean, probably thousands. Yeah, I don't know.
They're filing about 3,000 a year right now.
Yeah, and it's been an exponential curve probably these last 5 years. Yeah, I think 10,000 would be a good ballpark figure. I really don't. I know we've got someone on it, I think, in the front.
So as of March of last year, they have a press release saying they reached their 5,000 patent, 3,000 to 5,000 still in the pipeline.
So it could be 10,000 by now. Yeah.
Is open source actually that much more inherently risky patents than proprietary software? I mean, we watch Microsoft be sued for browser patents. Is open source actually that much more inherently risky?
I think it's actually less risky, if anything else, because you have so many. The question is open source software more risky than proprietary software? Actually, there's 2 sides to this question. On one hand, or 2 answers. On one hand, because your source code is available, it makes it easier for like Microsoft to come in and see, okay, well, you have this certain functionality that violates this or that patent. On the other hand, it makes it very difficult to sue the person who made that particular change. You can only go after the users. You can't go after the person who actually put in, the infringing code. Whereas with proprietary software, it's easy to figure out who owns this. Okay, it's this company, we'll sue them. And Microsoft has said that at least for now, they have no intention of going after end users. They're looking for, they're looking for bigger pockets. So in terms of you as the individual, I mean, I would think you're almost more protected using open source. But it's just my off-the-cuff opinion. Yeah.
My opinion too is essentially they have to shut off open source. They got to find some way to stop the exponential growth of open source. The longer open source exists, the more volatile Microsoft becomes. because they're threatened by just what the creativity of open source is.
No, it's an excellent point that the longer Microsoft or the longer open source continues.
They have to stop that growth. We become threatened just by its growth alone.
No, I agree. I mean, the fact that there's so many people who are involved in open source projects in and of itself is a threat to Microsoft. But then that may raise the question, that may raise the issue, well, maybe they're too late. I mean, maybe there are enough people now that once we figure out what these patents are, we can mobilize and diffuse any issues.
So I think most of their activity is going to be very silent. It's going to be threatening and silent without open threat. In other words, they're going to do most of theirs in back office without actually taking out the real business.
And the question is how long it'll work. I mean, if they just silently threaten, I mean, it's not going to be much of a threat after a while. You can only do that for so long before people say, well, gee, Microsoft's been saying for 2 years now that they have these patents and they'll sue on it, and they haven't done anything. So I don't know how long it's only a matter of time before someone calls their bluff.
Is all of this patent and copyright and, no offense, legal bullshit? Is this having a measurable, demonstrable effect on business in this country?
Yes.
A negative effect? I mean, is it worse everywhere else? Is this still the best place in the world to do business? What is this doing to development in this country?
Did you wanted to make a comment?
Yeah. In practicality, I think what it's going to do is stem the creativity in the United States, and we're going to become a third world nation because the rest of the world is not held by the same standards. So consequently, it's going to slow down our creativity.
Well, there's two answers to the question, actually. Our copyright system is modeled after it's very similar to what you have in Europe and what you have in other countries. So in terms of copyright, it's, actually, I'm not sure, and now that you mention it, whether software is eligible for copyright in all those countries, I'm not actually 100% sure of that. Europe it certainly is. I don't know about Australia and some other places, but copyright, everyone generally, everywhere is unilaterally screwed by this. Patents, however, is particularly bad in the US. Software patents do not exist in many countries, and I'm trying to think right now for certain any country, really. Software patents distinguish us in a bad way. And it's not just in software either. I mean, we allow you to patent genes, for example. I do a lot of biotech related research, and the amount of things that get patented in the US that can't get patented anywhere else is staggering. The breast cancer, when they found the genes that can lead to breast cancer, can up your chance of getting it. Merck was awarded a patent in the US but denied a patent in Europe and Canada. And I mean, the reason why is our standards are so much more lax. So yeah, I mean, in terms of will this hurt us in the long run, I mean, that's a good question. Part of the problem is it's US businesses that are getting all these patents. So we're hurting ourselves, but then we're milking the rest of the world for what it's worth.
Is that actually happening? Are smart people going to other countries other than the US to do business?
It's actually happening. In biotech, we've seen companies that have started branches in countries that have friendlier patent systems. I think Denmark comes to mind as one of them that doesn't allow gene patents, at least not nearly to the extent that they do here. So yeah, it is happening. It's beginning.
So you can also look at the number of companies that are starting to IPO in European markets.
That's because of the Sarbanes-Oxley Act, which is so restricted that now Europe is getting a lot of IPOs. Isn't that correct?
I'm sorry. Can I pause you? I had to replace the tape. Could you make a statement about biotech and the flight of countries? Flight to other countries?
Going back to biotech, we are already beginning to see companies that are moving outside the United States because there are more lenient patent systems in other countries where they can't be found infringing. So yeah, we're beginning to see companies that are leaving, because of the IP system that we've set up. So it is going to hurt us, and to some degree in the long run. In the blue.
Can you say what or who is driving patent reform that you alluded to?
That's a good question. It's actually everyone against everyone. You know, the drug companies are pushing patent reform because they want more concessions, you know, for the amount of time it takes to develop a drug. The cell phone, the telecom companies, it's everybody who wants either, who wants to be shielded from patents from their competitors, or who wants to get additional power out of the patent system. But the thing is, there's also a lot of nonprofits that are involved, a lot of professors, a lot of people who want to see meaningful reform that have a voice in this process this time. And that hasn't happened in the past, and it certainly hasn't happened with copyrights. Yeah.
Just a response to the earlier query, in the database here, we're showing about 38,000 patents for Microsoft.
38,000 patents for Microsoft.
That's the first one that has to do with DRM.
So that is far, far worse than I would have guessed, 38,000.
So, quick question. You had mentioned the possibility of unfair competition lawsuits. Could you say anything about the legal climate in Illinois or anywhere else for the possibility of a DA bringing such a suit?
I wish I could, but most of my practice experience is in patent litigation, which is in federal court. So I haven't dealt with unfair competition claims enough to be able to tell you. In the green in the back.
So a lot of open source projects that knowingly infringe on U.S. patents are based in countries which either don't have software patents or are friendly to those types of projects. What is the liability of a U.S. resident who contributes code, patches, knowledge to those projects, even though the project itself, the code itself is owned in an overseas location?
The fact that it's, okay, so the question is, if you're a U.S. resident and you are contributing to an overseas project, say in a country that's sheltered from U.S., from extradition, U.S. patent laws or what have you, to what extent can you still be hauled into court? Because you're a U.S. citizen or you're in the U.S., you still can. If you're contributing to something that is leading to patent infringement or copyright infringement, just because, say, you're doing it for a company or an organization that's in another country won't be a safe harbor. In the center?
Didn't the Microsoft AT&T ruling recently sort of change that a little bit?
That was a little bit more complicated. That involved components that were infringing components that were being made overseas, where part of the infringing activity wasn't taking place on U.S. soil.
Okay, so what you're saying then, if you were working on a project and you happen to be working on components of that project that are not necessarily infringing, are you liable then? Can you touch the project safely at all in any places?
I see what you're saying. I would still, and I'm taking a guess on this, but I would still think if you were living in the U.S. and you were contributing things that constitute patent infringement, that's going to be more than enough to bring you into court for a patent lawsuit, even if the company or the organization is acting legally, from an international standpoint. You're still a person in the U.S. infringing a patent, so that would put you in danger.
Can you summarize those questions?
Oh, sorry. Okay, to summarize the question again, this is with regard to a company or an organization that's in a country that has less restrictive patent laws, but you live in the U.S. and you are working for that company or you're volunteering your time and you're doing things that in the U.S. would be considered patent infringement, but in that other country would be considered to be okay. Can you still be sued in the United States for patent infringement? I think the answer is yes, because it's your own activity in the U.S. that's infringing.
That wasn't his second question. The second question had to do with if you're acting in an area of the project that is not infringing.
Okay. What happens if you're in the U.S. and you're acting in an area that's not infringing? No, I don't think they'll have anything to get you for in that case. You're not responsible for the acts of your employer abroad or this organization that does a bunch of things abroad. Don't quote me on that if it's a terrorism issue. But if it's IP, if we're talking about patents and you're not actually doing something that's infringement, I don't think you would have an issue. You're not responsible for other people's actions.
Unless you're a director or something.
Yeah, unless you're management, you know what's going on and you're kind of organizing the whole thing. If you're liable as, like, say, the CEO of the company in a contributory sense.
Let me continue on that, Peg. Who has the burden of proof to prove that you are not infringing upon their patent?
If you get sued for patent infringement, you have the burden of, well, they have the burden, the company that's suing you has the burden of proof to show that you're an infringer. I think that battery just died. You have the burden of proof to show that to show the person is infringing. However, in civil lawsuits, it's merely 51%. You know, more likely than not to establish guilt or to establish a violation. So, sorry.
We're experiencing technical difficulties. Please stand by.
So to go back to your question, if you get sued for patent infringement, it's the person suing you who has to prove the case to the jury. It has to be more likely than not that you are infringing the patent. But the problems here, first of all, you have a jury, which, you know, assuming you have a jury trial, they can often easily be swayed, regardless of what's actually going on, depending on how good the lawyers are on the other side. And two, if it's still a pretty low threshold, it's not like a criminal case where you have a really high threshold to show that you're actually, you know, committed the crime. I mean, it's one of the problems where when these patent laws were written, when all of this was figured out, these weren't things where an average person could potentially be held liable for, you know, millions or billions of dollars of infringement for something they had no idea they were doing. I mean, it's just gotten, you know, the stakes have gone up so much, really within the past 10 years, that it's really quite nasty now. Yeah.
How would, if, let's say Microsoft sees this recording and says, wow, she's really smart, throws, you know, $5 or $6 million your way, and Melinda says, oh, you went to my school, and you're their lawyer, how would you advise them? What would you tell them would be their best course of action to get Linux and you know, use that, maximize their damage to the open source community?
First, the question is, what would happen if Microsoft lured me away today and I was to advise them? First, let me say that I left private practice because of the disgust of these patent suits in the first place, and that's why I'm in academia. What would I advise Microsoft? I would advise them to bluff and bluff and bluff as long as they possibly can, because fear is what's going to cause the most damage here and not these patents.
Litigate.
Yeah, the most you can scare people and make companies think that there's a threat, you know, the more that they're able to do that, the more success that they're going to have. So, yeah, I would say that's what I would tell them. It's an unfortunate situation that they can get away with it. In the red?
I remember fuzzily a while back, and I don't know if it was a suit or just an argument, but some university in California had some kind of patent on the browser operation with Microsoft, and whatever happened with that?
It's being appealed. Microsoft's appealing the decision. They're trying to get the patent revoked.
Okay.
Retroactively. Microsoft lost on the appeal for the actual case, and they were awarded $600 million in damages, I believe. EOLIS. Does that sound right?
Yeah.
Yeah. And Microsoft is trying to get the patent invalidated currently.
Okay. I hope that answers your question.
That's why they're in that program then.
That's why they're in that program. I still don't honestly know why they're in that program other than trying to repair their battered, tattered image, but I mean...
Judge the effectiveness of it. It's a pilot. Find out if it's going to work, and then if it is, then get your lobbyists and everybody to stop it.
Well, and one possibility for why they're doing it is that so they can try to sabotage the other people who are in it. You know, there's there's talk about whether you can game the system in the peer-to-patent program by, flooding the examiner with lots of irrelevant prior art, or, and granted, they're using almost a slash dot system to handle this. What they're doing is you get sort of a score, and the more useful pieces of prior art that you give to the examiner, the higher your score gets. Exactly, you get the +3 insightful and funny comment, and how well this is going to work, no one knows. I mean, it's one pilot, and so it's whether or not they'll be able to game the system. I mean, it could happen. Yeah.
The best possible outcome for Microsoft in the patent system is that there be strong, respected patents and a small number of those, and no crappy patents. Because they are the deepest pocket and they're the biggest target. So they're interested in peer-to-patent because they don't want software patents invalidated altogether. So something like peer-to-patent gives them a sort of an intermediate where they can say, oh, well, look, what's left of software patents, these are good, these are okay. And so that way they get to protect themselves and pursue others, pursue us.
But I think it's more of a PR stunt than an actual legal strategy. At least my experience in dealing with people, I haven't prosecuted, I haven't dealt with people who are filing for patents. But my experience with working with companies who are suing is they'll do anything to get a patent, no matter how flimsy it is, just so they can hang on to it and either go after people, scare them, or have it as ammunition in case they're sued and can, flash it around and hope the suit goes away. So I don't know. I don't know how much is it that Microsoft or even these other companies want good patents. Because obviously they could do their own research. I mean, if Microsoft didn't want crappy patents today, they could just go and look for prior art. Yeah.
Well, but it's a lower cost to them to, if they can make the patent office only issue better patents, because they have so many more resources, they're more likely to get those than the little guys are.
I still don't think, but I don't think resources is an issue for Microsoft. I mean, I think
but they don't want to lose resources to the little guys. In other words, if there's a bell curve of patents, they're convinced they're up there at the tip, and that they're going to get those. As long as there are any software patents, they think they're going to get those. And whereas if there's a broad range of patents, then they've got to deal with all these little flies that they'd rather not deal with. So, but I'll shut up and let you get back to it.
Anyone else? Yeah.
Let's say that tomorrow there was a new code base created corresponding to a new software product, and I attached the GLP v3 to it, but I crossed out that grandfathering date that's associated with the Microsoft Novell contract. Could I stop Novell and SUSE from distributing that package, but allow Red Hat and Debian and all the other folks?
That's a really good question. The question is, can you change the GPL? Can you strike out part of the GPL, say that date that Novell is not affected, and say my code is under this license? The answer is Richard Stallman will not let you. The Free Software Foundation, this is the funniest thing. It's open source software, but not an open source license. You can't take the license and tinker with it and give it a new name without their permission. So for those of you who are familiar with the Faro license, they actually went to the GPL and said, hey, we want to do a version of the GPL without the whole Google loophole of companies that are distributing stuff on the web being exempt from having to distribute source code. But they got permission from the FSF. They actually protect their license using copyright and using trademark. So you could rewrite something similar, on your own. You wouldn't be able to call it the GPL, and it couldn't use the same language.
But it would stop SUSE from distributing code, but it wouldn't stop Red Hat and all the other normal open source folks.
See, it's
It
tricky.
wouldn't work. In other words, as long as it's a new code base, the code base.
Yeah, you're assuming it's a new
exists.
code base. I mean, it's your code base. You can write any license you want. So yeah, you could write, the Joe Bob license. And the Joe Bob license says, Novell can't do this, Novell cannot take my software and do anything with it. In fact, Novell can't touch it. And, you can then say, but everybody else who, is using the GPL, they're okay. I mean, you can write your own license.
Yeah, that actually wouldn't be open source under the open source.
But see, yeah, that's the problem. You didn't get the
And
OSI definition.
Another company just tried to write a very GPL-like license, and submitted it to OSI, and it was rejected on a few different grounds, mainly that it was incompatible with the GPL. But it's getting increasingly more difficult to get OSI at least to certify licenses
As open.
as open source.
So the comment was that it's getting increasingly difficult to get your license certified by OSI as being, OSI open source.
But also excluding certain groups actually violates the open source definition. So even if OSI doesn't certify it, you don't even meet the open source definition. Nobody else will.
But to go back to your question, I mean, you could write something very similar to GPL v3, only it doesn't have that language that was once in brackets. It doesn't say anything after this certain date, and you could release your own code under it. You just can't call it the GPL, and you have to change the language of it.
Okay, that's fine. It's just that I thought that the reason for that grandfathering date was because we had a pre-existing code base that existed at the time this agreement was made between Novell and Microsoft.
Well, it's interesting.
So it's because we have all this old code sitting out there that we had to put that date in there. That's a wrong impression.
Well,
I'm not.
actually, my impression of why they put that date in there was because of other companies that had already entered into agreements that would have otherwise been affected, but were more innocuous compared to Novell. And they didn't disclose who these companies were. And Stallman made an offhand comment in his speech saying, well, there are these companies out there that will be affected if we put in this date, and if we don't put in, if we don't have a cutoff for after, this date, and it's going to unfairly affect them because they didn't know when they entered into the agreement that it was, something that the FSF frowned upon.
But if they're relatively innocuous agreements, why can't I make them in the future? Because the deadline date, now the innocuous agreements can't be.
Now you're hitting on why does Linus Torvald hate GPL v3 or at least very strongly dislike it. It's because there are arbitrary decisions that have been made in this license, and so GPL v3 doesn't encapsulate all of, freedom and goodness necessarily. It makes judgment calls. I mean, the fact that the DRM provision only applies to consumer devices, but it's okay if you're supplying commercial devices with DRM in it, that's GPL, that's fine. I mean, there's some really weird arbitrary lines that have been drawn, and the reason why I think they exist is because there were so many people at the table saying, oh, well, we can't have this because our company will fail. We can't have that. I mean, all the big players were asking for different things, and that's why we have this long, convoluted license. Yeah.
Yeah, I might add that the language that covers that is so convoluted that if you're a company like IBM and you've got literally thousands of patent agreements, there's no sane way without paying lawyers like $1 gazillion to go back through and audit all of those old contracts. But now that you've got the language in front of you, you can make sure you don't infringe it with future contracts going forward. Does that make some sense there? So in part, this is a clause that lets IBM and Sun and other companies with literally thousands of patent contracts not go back and look at their old stuff and not have to audit all that old stuff.
When you've been licensing patents for God knows how many years, and you've also been contributing to open source, and hell if you know if one of those patents happens to cover something that is open source because you had no intention of suing, right? So those people have the potential of getting caught up if there hadn't been that cutoff date. So that as far as I can tell, is the rationale.
Go for it, Cindy.
Yeah.
The scenario
we were talking about with European no software patents. Suppose a company formed and started a brand new code base, did all of its development with European developers, and published under some open source license, and distributed the product in the US, and some corporate entity looked at it and said, we have a patent on this. Can they sue that company?
Yes, because they're distributing in the US. That's the kicker. They can sue the distributor and they can sue the company that's allowing the distribution. Now, if the company doesn't know about it or isn't facilitating it, like let's say you create some kind of an open source code base, you put it on the web, and you're in a country that isn't particularly, doesn't have great relations with the US necessarily. The fact that people in the US can still download it and do whatever they want and it violates patents, I mean, we may not be able to, it would be very difficult to reach that company and do anything to them. But if you're distributing it in the US, that's going to be enough to trigger the patent law.
But an innocuous web distribution might not.
It would depend, yeah, there would be a number of factors involved if it was a web distribution. I would think you'd be safest if you were in a country that generally did not care what the US thought of your web distribution, to be on the safe side. At the very back.
So in that scenario, what if you as a U.S. company purchase software from that company even though they do no business in the United States, maybe from one of your European subsidiaries, but you use it in the U.S., you were the target?
Yes, if you were using software in the US that violates a US patent, that's still sufficient to be sued under US patent law, even if it was developed in a country where it wasn't in violation. It's the fact that it was imported into the US. You start hitting trade laws, actually. You could get pulled into the International Trade Commission because you have a trade issue going on where you're importing something that's in violation of a patent. Or you could just get taken to federal court under regular patent litigation.
When that code is being run in a mesh computing scenario and you don't know where the actual process is, if you get an injunction that would prevent U.S. operators of the mesh computers from allowing that code to run.
Okay, you're going to have to repeat that because I'm not sure I followed it.
Okay, you know what mesh computing is?
I'm not sure I do. I'll have to explain.
You have distributed computers.
Okay, it's distributed, all right.
Okay, the code runs, you don't know where it's running, you just, you put in your input, you get your output.
And you don't know anything about the code.
Yeah. So, but it's this previous scenario, right? This code that was developed completely outside the U.S. Now, could somebody in the U.S. That's claiming you're infringing go to a U.S. court and say they're infringing and at least stop them from running this on U.S.
Okay, so the question is, if you're in the US and you're using software that you have no way of knowing infringes because it's on offshore computers or the like, or you can't look at the source code or any situation like this, but you're using the software in the United States, can you be sued for patent infringement? The answer is yes, because you're a user of infringing software. I mean, whether they'd be able to figure out, how they'd find you in the first place, there's probably logistical issues, but as a theoretical matter, I mean, if you're using something that violates a patent in the U.S., that's enough. Yeah.
You kind of indirectly started to allude to earlier, I think, and we never went down that path. What do you think about defensive patents? Should companies like Red Hat and/or individual open source developers be filing for patents?
That is a
we
really...
don't approve of patents, but do we need them pragmatically for defense?
That is an excellent question. Do open source software companies, developers, etc., need patents to defend themselves against anyone? And I think the answer is unilaterally yes, you do. Because the way the patent system is right now, anyone who does something, anyone who codes, anyone who does something that someone else might want a piece of, I mean, you're at risk for being sued. Now, as an individual developer, what the probability is of say Microsoft coming and hauling you into court, it's probably not very high. But in terms of companies, it does make sense. Like Red Hat, for example, has a patent portfolio. It does make sense, but you have to you have to trust the company as well to not get a new board of directors, go SCO, and then it's all over. Now, can I point at go SCO? Kind of like going postal, yeah, in the back.
At this point, I'd like to point out that Red Hat has something we call the Red Hat Patent Promise, just to remind everybody. And the reason for this promise is to allow us to develop a defensive patent portfolio. But the promise states that if you are a developer of open source software and you put software out under one of the protected GPL style licenses that ensures a continuing development of the commons with that software, we will not pursue legal action against you. And we've written that promise down in writing.
Well, so then I have a question for you. If Red Hat got a new board of directors tomorrow, and they were really greedy and decided, gee, we don't like this promise, we want to milk these users for all we can get, I mean, what would keep that promise intact?
My understanding is that that promise is kept in place through a principle called equitable estoppel, which means that because we have said it in public and people have relied upon that, the principle of equitable estoppel says that since you made it in good faith and people believed in it, you can't no take backs.
Now that is an excellent point. In the U.S., if somebody, this is what I was saying a little bit earlier with regard to how the GPL has changed, so that if somebody licenses their work under an open source license and then turns around and tries to sue, you're stopped from being able, you're basically blocked. You can block the lawsuit because the idea is you relied on a promise, and because that promise was there and you relied on it, you can't get at past infringer or past uses. The problem would be down the line, you could dismantle the promise, and then everyone, going forward would be at risk.
When that gets slashed off, we're done.
Good point.
Can't they just, as an open source developer, can't they just sue all my users anyway? Does that patent hold water at all? That promise hold water at all?
The promise holds water with regard to, if Red Hat or any other, any other patent owner says, we have a patent on this technology, but if you're using open source software that uses this patented technology, we will not sue you.
Right, but that's not what he said. He said that they won't sue the developer of the software.
That's a good question. How broadly is the patent promise worded? Is it just for the developer, or is it for the users as well?
Well, the promise was written in 1999, so it's my understanding that right now it only applies to developers. So maybe somebody could take that to Mr. Webbing. Is that?
Well, I'm not
Mr. Webbing's representative.
Yeah, I'm not Mr. Webbing, and I'm not a lawyer, and I'm not Mr. Webbing's representative, but I do have it in front of me. And it says,
he's the intern.
Yeah, I'm just an intern. To the extent any party exercises a patent right, in other words, to the extent that any party uses the patent or infringes on the patent, Red Hat agrees to refrain from enforcing the infringed patent against such party for such use. And there's some things in there that make it specific to open source software. But yeah, so it's any user, period. It's a good so. Yeah.
Okay, I think that my voice is probably going to give out if I take another question. So I think this is going to be the end. Thank you very much.
Thank you, Sapna, for your presentation. I just want to thank once again Resolve It for our meeting sponsorship this evening. The Carolina Open Source Initiative for audio and video support. And as always, we thank Red Hat for hosting our meetings.